So, but I'll start by asking Mario what major risks AI brings to individual rights and of people, and in particular, what is new that AI brings, but that we still don't have with other digital technologies. So, what new challenges does AI brings in what respects the fundamental, the violation or possible violation of fundamental rights of people?
So, good afternoon. So, what is new? What is new? Are you interested in seeing what is new with this new wave of generative AI, ChatGPT, and all that stuff? Well, what's new in AI with respect to other technologies? So these are, I think, two very different angles. But focusing on what is new in the more recent technologies like generative AI, large language models specifically, and ChatGPT, that's what mostly people think of when we discuss these new techniques. Is sort of they provide for the first time access to AI to lay people, which was so anyone can interact with AI and ask questions and even with a bit of effort, not too much. There's lots of tutorials that allow you to build some little applications. So it lowered the entry barrier for using AI quite substantially. And so I think that's something that is new. Because in terms of risks, it's not clear exactly what are the largest risks in this. So in more traditional AI, and I think we're all aware that by far the biggest application of AI in nowadays in current society is in social media. So the social networks are where AI is used billions of times per second everywhere. Those are obvious risks that we all know about. And with this new wave of generative AI, so it lowered the barrier a lot to, for example, to the creation of disinformation and fake news and in massive amounts and with very low friction for doing it and for disseminating it. And so I think that's from my perspective and in my opinion, currently the highest risk of AI and of the power of these tools is in disinformation and the impact in elections, and those are the ones that worry me most. There are many other risks which you can discuss along the panel, like
one risk that is taken. I mean, maybe just two additional notes. One is privacy, right, as face recognition. And the other one is
well, that's not new.
Biases because of automated decisions. So
which is also not new. So I was
not news to this.
I was focusing specifically
new wave
on
of
this
AI,
new wave of generative AI, which lowers the barrier for the creation and lowers the friction and the difficulty of creating a huge amount.
But you agree that on a wider scope, privacy violations and biases or other sort of discrimination are risks by using automated AI systems.
Yes. So I like very much an expression of that François Chollet uses, which is current AI is cognitive automation. So we have a way of automating cognitive processes that were exclusive of humans, and now they're automated. We can have machines that do these processes that used to be cognitive processes, dealing with information and taking decisions based on information, and now we have ways of automating them with all the associated risks that we're all aware of.
Okay, I think we may come back to this information later on, but first I'd like to give the word to Tobias, maybe he's nearby. Are you aligned with these worries about disinformation, other risks that come to mind, and what is the legal take on this? Do you anticipate a lot of business from AI challenges, or your worries are different?
Yes, well, first of all, thanks for inviting me here. I am a law professor at the University of Oslo, so my business is teaching and research. And I think in that respect, the AI Act and the evolving landscape is really a good chance to teach students in these questions and also to do research, because there are many open questions still. And within the legal landscape, I think the risks that you mention are absolutely relevant, but they're also addressed by laws that date the AI Act. So in terms of the Digital Services Act, it deals with risks with respect to online platforms, where disinformation and impact on elections are amongst the issues that platforms need to assess already. So, and it's interesting to see that this is an area where we already have some kind of risk-based regulation. It's not called risk-based regulation, but certainly it obliges companies to do risk assessments of specific issues. So that's one way of being risk-based. It also establishes certain categories of entities being regulated, and that is, I think there is a risk thinking behind it, but it's based on size rather than risk in abstracto. And then the other laws, obviously, of relevance to privacy and biases are non-discrimination law and the GDPR. So I think it's interesting to see how the AI Act will interrelate with these other pieces of legislation which already exist, many of which focus on the actor who is applying AI rather than the developer of AI, which is the original first focus of the AI, the AI provider.
No. Do you want to add to this? And may I ask you an additional question? Is do you anticipate a lot of legal challenges brought on by the application of the AI Act and related legislation, or you think it's clear enough and will not be the subject of a lot of discussion?
I'll start by the end. This is 13 chapter, 113 article, 13 annexes, 180 recitals, and 68 definition act. So the answer to your question has to be absolutely. This is good basically for lawyers and for standard setting organizations. Other than that, I think that this regulation tends towards being bureaucratic disgrace, just on the basis of its complexity. Meaning, if you have something that is very reasonable, but you take 113 articles that sometimes have many numbers to explain it, I think you failed. So this is, in a way, I think this is going to be very, very challenged each and every step. Just if we think about the forbidden practices, determining the scope of some of those very qualified language in terms of detrimental, substantial, material, all of these qualifiers are where lawyers thrive and why some people hate lawyers, especially engineers. With that, I also agree with what was said, that there are a lot of things here that are not new, neither from a technical perspective nor from a regulatory or legal perspective. Actually, I also teach, and what I tell students is you may not like the answer, or the answer may not be right, but we lawyers will always have a legal answer to a legal problem, because we even have a method to solve gaps. Now, most of the challenges were already addressed under GDPR, under the Digital Services Act, under the constitutions of member states, and so on. Another thing, and I'll finish my intervention now, that I think will challenge this is, and we'll talk probably a little bit later, is we're all talking about fundamental rights. I actually, because this is the subject of the panel, I searched, there's 103 occurrences of fundamental rights, the expression in the AI Act. But people tend to forget Article 51.2 of the Charter of Fundamental Rights of the European Union, which actually says that we cannot invoke fundamental rights to extend the scope of activity of EU law. And this is going to be very complex, especially when it comes to law enforcement, border control, and so on. And the AI Act has decided to go into that venture. This is, for instance, something that I expect to be very much challenged in the Court of Justice, even on the basis of competence.
Did I hear from your intervention that if you were to write an AI Act, you would have done it differently, more simple on addressing other issues?
Yes, that's an unfair question because I think everyone involved would have. The problem is compromise. The problem is compromise is lobbying 36-hour sessions. So I'm not criticizing each and every person that was involved. I'm just looking at the final outcome.
A camel, you would say.
Yeah,
Okay, so anyway, the AI Act has been approved, as you know, so the discussion about what should be in there is not that relevant today. Maybe 1 or 2 years when new discussions come about, but not now. But the focus on disinformation that you made is something that is a bit new in the sense that we are afraid that many more people will be able to start massive disinformation campaigns, right? It becomes much easier. You can get personalized messages, even possibly pictures and videos and so on. Since that technology is relatively new, is not really taken care in any of the previous acts, right? Because neither Digital Services Act, this sort of deep fakes, right? The deep fakes are new today. Do you think the AI Act addresses them, or you think, asking to be, do you think the AI Act addresses that, or we should go back to the DSA and the DMA and they are enough for that in a way?
Well, I would say that the question of disinformation is bigger than deep fake. The Digital Services Act does actually address disinformation risks related to platforms. So platforms need to deal with disinformation risks. But this is basically an answer to experiences we've had with big platforms over the past 5 years or so, where there were big discussions about Meta and other platforms and their roles in disinformation. Disinformation is also addressed in some ways in the AI Act. And there is a special provision focusing on deepfakes. So deepfakes need to say, "Hello, I'm a deepfake," which is useful because otherwise we might not necessarily know. And there have been confusions there. But so fundamentally, I think that's really about what is it to be human and what is it to be an AI, and making that distinction will be more and more challenging, as we've also seen from the latest edition of OpenAI's products. But other than these deep fakes, the generative AI were not regulated as high risk under the very first proposals. So there was a recognition that maybe we need to think differently about those types of AI systems that are general purpose, because the original idea with the AI Act was very much focused on specific purposes. So even the year before the AI Act was proposed, the Commission said, next year we'll tell you which sectors we will regulate. And I was thinking, okay, which sectors are you going to regulate? AI, it's fairly general. And then they basically came up with the idea of what is now Annex 3, where you have a list of types of AI systems that are considered as high risk, and where those kinds of general purpose AI systems were simply not included. So, but then as mentioned in the first panel already, there was a recognition that we need to address this, and there was a recognition that probably this does not fit into the risk-based approach where one has prohibitions and then high-risk AI systems which are regulated. This had to be regulated in a separate column, so to speak. There is this nice pyramid that most of us probably have seen, and there is then a separate column for general-purpose AI systems, and those with specific systemic risks. And that's where the disinformation risks also come in.
So actually, when I read that very quickly, but that special it's chapter 5, I think, right, on
Yes.
the general purpose systems, I was not particularly happy with the definition. There are two sorts of definitions. One uses adjectives, right? Significant, important, relevant, potential, and stuff like that. And then there is a very specific number there, which is 10 to the 25th floating point operations per second. And none of those approaches to the definition of general purpose systems look very future resistant to me for several reasons. We just learned recently, 2 days ago, I guess, or 3 days ago, that the Portuguese agency that will regulate, that will be responsible for the enforcement of the AI Act is ANACOM, the Agency for Communications. Do you think ANACOM, and I was going to ask Nuno for this, do you think ANACOM will have the resources and the ability to regulate this, to discriminate what are general purpose? Of course, much of this will be done at European level, but some cases no, right? I mean, we have Portuguese models and stuff like that. So do you think the regulating agencies, put more general questions, will be able to apply the legislation, distinguish between general purpose systems, and then if they are not general purpose, where they fit into the pyramid? Do you think that is a doable task? Easy, I think you agree it's probably not, but is it at least doable, possible? Because just to finish, I was discussing with a vice president of Google, and he said, this is impossible, this cannot be done. Of course, Google has their own opinion on these matters. It's not exactly an impartial subject, but he was arguing that cannot be done. So, Nuno?
Yeah. So a few things, just a small joke, not to offend anyone, but I guess some of those institutions may still be running Windows 95. So I'm not sure that all market controlling authorities will be capable. ANACOM, I think it's the obvious choice. They've been chosen pretty much in all of the new wave of legislation. So they are also the digital services coordinator for the DSA. And I think it makes sense to concentrate the expertise on one single entity. And out of those in Portugal, it would either be the Data Protection Authority or ANACOM, and I think it makes sense to be ANACOM. So the choice is there. About the capability, I think that this new wave of EU digital law kind of started with the GDPR and increased significantly from in the last 5-6 years. It's the era of EU law brutality, where they make acts, they are increasingly big, the fines are huge. Has also been the recognition that there are two levels. There's one level at which the EU has to act like a state, and therefore you put the supervision at the Commission level. And that's basically where you're dealing with the GAFAM, the Google, Alphabet, Facebook, and so on, as if they were foreign states. So there's even an approach in my mind of international policy. So it goes well beyond just strictly applying the law, and you have tailor-made rules for them. And then there's the national level. And at the national level, I mean, I'm talking too much probably, but at the national level, it will very much depend on budget. That's my view. How much money do these entities have? Because expertise is costly, but you can get it provided you have money. No money, no clowns, as we say in Portugal.
Yeah, so creating the financial capacity and also finding the human resources will probably be a challenge in almost every country, but maybe even worse in Portugal because of salary levels and other issues. So, but still, Nuno, you think as long as you put enough resources on this, there is no fundamental reason why the act should not be enforceable by ANACOM in this particular case?
No. There are many things. So, I mean, you can still do nothing with a lot of money, but you cannot certainly do anything if you don't have money.
Yeah.
So I think there are a lot of conditions that you need to meet for this to work, but I think the fundamental requirement is if there's budget here. in Portugal, I think we have significant expertise in terms of law, but also engineering. We have successful companies in this field, so we could position ourselves. Spain tried that. They tried to even before the act was in force. And the commission already created the AI office well before the act was in force, just in January. And they're already hiring. So maybe Technical can send some students
over there. So I was going to move forward and go into the topics of transparency and auditability that are set forth. For someone from computer science, these systems are very different from traditional information systems. In principle, in a traditional information system, you can have warranties that it will work in such a way, and of course there are bugs, but as long as the bugs are not particularly relevant, you can have fairly strong warranties that a thing will behave in a given way, right? I mean, a form will not start spitting out hate speech or something like that. These, in particular, large language models, but also in some way vision systems and so on, they are not exactly traditional programs in a way, right, Mari? So do you think we can still make them transparent and auditable? And in particular, can we provide warranties about their behavior that are in synchrony with what is the spirit of the AI Act?
I'm very skeptical about that, because knowing how research is done in these areas, it's almost halfway, well, it's a mixture of engineering and biology. You treat these systems almost as if they were living things, because they are so complex that a lot of the research is completely empirical. You try things like if you change the food for this population of dogs and see if they behave better. It's almost like that. You change some parameters in the training process and you see what happens. It's very hard to predict because they are really complicated. So, whereas in more traditional machine learning systems, you get even if they are pretty complex, you can get a glimpse of what's going on, like say just a deep learning architecture for some vision problem. But in generative AI, there's so many layers and they're so complex in so many ways that they're very difficult to audit from this perspective. Transparency, explainability, I'm very skeptical about that. There's a lot of work on explainability for large language models, but none of it is very successful. I'm not even sure if that's the right question, because even for humans are not explainable, right? We don't really know why we say what we say, right? I'm saying this, and I don't, very often when people say things, and you ask, why did you say that? What are your bases to saying that? You switch into a mode of justifying what you just said, rather than explaining. And explanation and justification are different things. And these machines will probably, for some reason, because of the way they were fine-tuned and the way the human feedback reinforcement learning was acted, these systems like ChatGPT, you've all probably seen these, they don't work very much in this mode of trying to justify themselves. As soon as you push them, they will, maybe not, maybe I'm wrong, maybe I'm wrong. They always say that maybe I'm wrong. Which humans are not like that too much. Humans have a tendency to try to stick to their points and try to justify what they said. And they come up with reasons very often which are not the real reasons why they said it. And maybe a lot of people take, as Kahneman well explained, we make decisions and we say things, and we really don't. The true reason why we said these things are very complex, and has to do with emotional states or with lots and lots of things. And I think these systems are almost at that level of unpredictability. Not as much, but they are, in my perspective, sufficiently complex to be very, very hard to have hope that we'll have some sort of, because I don't even know what it would count as a good explanation in that case. There are other levels where they can be audited, like on what data were they trained, okay? So if you have a large language model and you know exactly, or more or less, the data from which it was trained, you can get a guess if it will have some biases or not. For example, if it was trained on 90% of English data and 10% of, say, other countries, you know that you have a strong bias for the English language. So this kind of things that can be done on if you know. But in some cases, we don't even know that, right? For GPT-4, we don't really know the exact composition of the training set. But this is a very high level. You don't have guarantees like you have in formal computer science. So I'm not very optimistic about the possibility of having explainable general purpose AI. It's almost a contradiction.
It's almost a contradiction. So actually there are two issues here. One is explainability, explain why it reached a decision, and the other one is warranties. Can we have the warranty that a system will not, start saying hate speech or dumping some text that is copyrighted and so on. From a legal point of view, and if an engineer says, we have here, let's stick with LLMs. We have here an LLM. We did all we could do to try to make sure that it's relatively safe, but we cannot really promise that it will be safe in every situation because these things can be manipulated, much like humans in a way, right? They can be manipulated. So, from a legal point of view, do you see this as? There'll be a way to go to do this, or will be mirrored in endlessly discussions on whether the system was well designed or not well designed, whether a fine should be applied or not. Did you see my question?
Yes, I think it depends a lot on the type of technology that is applied and also the context in which it is applied. If we talk about large language models, then probably we are in the domain of general purpose AI. So much of the AI Act will not apply, and only very few obligations will apply. So you have to provide some basic information about what this system is doing, and that should be...
So it's less rigid for Chapter 5 systems.
Yes, absolutely. But then if it's a general purpose AI system with systemic risks, then you have to address those systemic risks. So you have the qualification of being a general purpose AI system with systemic risks, and then you have to look at those risks. So I think transparency there is different in terms of you have to look at the specific types of risks that would be relevant in that context. And just spitting out hate speech as such would, maybe I'm saying something wrong here, but I would guess that this wouldn't necessarily amount to the level of systemic risk that is relevant for the AI Act, unless it's really, so you could really say it's a systemic risk as such, but it would certainly play a role for the Digital Services Act where these systems then could be applied. So you have a different regulatory regime depending on which act you are in.
Nuno, you want to add something to this?
Yes. I think, so I've rebelled against the idea of explainability as a legal duty that could be imposed. I think best things in life are not explainable, and I don't think that we should change it here. But I think there are three concepts. One is transparency, and transparency can cover all of the development life cycle, from data selection all the way down to on what servers is it running, where are the servers located, and so on. And I think that's perfectly imposable from a legal perspective, and there are many glimpses of that all throughout the AI Act. A different thing is interpretability. So can we understand how does this work? And then is explainability. Can we explain how this particular inference was made? So we can have a system that is transparent, that is interpretable, but that is not explainable. Now, it's funny to see what the AI Act did. I think the AI Act did in Article 86 as makeup, because it says, if you read it, it says, right to explanation of individual decision making. And you think, oh, they're referring to explainability. Not really, because if you go here and read it, it says that only in certain cases of Annex 3, then the person shall have the right to obtain from the deployer clear and meaningful explanations of the role of the AI system in the decision-making procedure and the main elements of the decision taken. So I don't think that there's anything in the AI Act that actually demands explainability in that sense of understanding why Professor Mario got a much better quote for life insurance than I did. but we need to understand how does the life insurance quote AI system or pricing works. And what role does it take in giving me a different price than Professor Mario? So this is what I wanted to add.
Yeah, so we were concentrating on LLMs, which have their own challenges and are particularly complex because they're very, very complex systems. But of course, there are simpler systems that make decisions like insurance rates or admission to a college or to a treatment or so. Credit in particular. So all these systems, they are not exactly new in the sense that they have been used, some of them, for decades. And the issues already existed, but I think they are becoming stronger now because there is the exigence human in the loop. So in the way the systems cannot make final decisions or should not make final decisions, should be explainable or understandable or what was the, well, anyway. Interpretable. So all subtly different ideas. Maybe ask Tobias, do you think we have this clear enough? I mean, do we understand the legislation regarding this transparency and interpretability and issues, or is it something that we have to figure out as we go along and as we look at the cases that will be coming in and so on? I don't know if there are many cases about people complaining that I was unfairly not selected for this or was unfairly. Do you know, are there real cases that came to the courts and...
It's a good question. Some years ago, there were discussions about a very parallel rule in the GDPR, which also requires some explainability, and that was even included in the 1995 Data Protection Directive. And under the Data Protection Directive, there is no case law about that provision, and also in the early years of the GDPR, there was no case law. I don't know if there is any more recent case law. But it has been relatively little used, at least in the initial phases. But now then, if we are no longer with the large language models, but with these more specific systems, then we would be probably within the high-risk AI systems. So we would have to look at what type of case is it, why is it high risk? For example, if our university were to use AI in order to grade our students or to admit students or to hire new people, those would be use cases. And then in those cases, transparency requirements would apply to the AI provider, which has to tell the university, look, this is what the system can do. And these are the requirements, and here are some of the risks that might happen. And I would assume that the technology, let's say we were starting to grade students with AI, we wouldn't use GPT-4 based models for that, even though you can ask GPT to come up with a grade, and it will respond as it does respond otherwise too. But that's not a useful system. So one would have to come up with some kind of more deterministic system, which is less prone to error, because a system that is very prone to error would invariably discriminate some students, and we've seen that in the context of HR practices, hiring decisions where replications of previous biases happened. And in those cases, maybe these deep learning systems will just not be applicable because they are not good enough and they have too many challenges. So it's not only a question of transparency, but also functionality of the system.
But the AI Act does bring new impositions in that respect, right? I mean, there's new stuff that was not in the DSA or the DMA or the GDPR, right? So there are new requirements that are brought in by the AI Act that, so in a way, we will be able to use less systems now than we used before the AI Act. Am I right in that? Things that we could use, but now we cannot because they are high risk, let's say.
I think now it's much clearer what one has to think through in terms of questions. So the compliance work is much more severe and much more detailed.
Sure.
I think many of the key questions would have been very parallel in the absence of the AI Act. So let's say if our university was to use an AI system to grade students, we would have to think through, okay, on what basis are these grades assigned? How was the system trained? Would it be lawful under Norwegian higher education laws to use an AI system? And that question still remains. So I think that many of the underlying questions are just more explicit and perhaps expressed in a more bureaucratic way. But they couldn't have been disregarded before because fundamental rights obligations apply.
They were still there.
They were there before and they are there now. But it's perhaps a bit clear what exact steps one needs to carry out in order to comply with these fundamental rights obligations.
Okay, so Noon, I'll ask this one to you. So as you know, there are a lot of legislation on the right to complain about decisions in hiring, for instance, hiring public servants or in public procurement. All of that is open to, so companies can complain about. And usually the committees, the juries just say, well, we decided in that way, and they present some justification. If we start using AI on some of those aspects, which is a natural thing because we are looking for efficiency, and the AI can really bring efficiency in assessing, I don't know, the quality of a proposal or whether the numbers are right and so on. And then people complain. Do you think we'll be able to answer those complaints in the same way that we use by basically, I mean, now we just ask the people, right? Why did you order in this way, right? But yes. if we are added by AI systems, and the systems are not as good as explaining themselves as humans, do you see a challenge here that, I mean, we'll be using technology, but then it does not fit in the legal framework where people can complain about the decision?
Sure. So any good lawyer is trained to answer any question with "it depends." And I'm not a good lawyer, but I'm going to start in the same manner. So basically, we'll have to distinguish what role is the AI system playing in that regard. So if you're using that in hiring, for instance, that is in Annex 3, so it's presumed to be a high-risk system, and therefore subject to all kinds of regulatory requirements, because this is the AI Act, but it's really about the high-risk systems. It forbids most of what would already be forbidden. It minimally regulates other AI systems, but it's really about high risk. Even those large language models, they are regulated at the model level, but they become relevant only if you make them part of a high-risk system, or they become more relevant if you make them part of a high-risk system. Now, if it's a high-risk system in that regard, it will still depend on what you're using it for. Because if you go to Article 6.3 and you say, well, I'm using this in hiring, for instance, but it's only to do a restrictive procedural task. For instance, it ranks it applies a mathematical formula that was decided by the jury, but it's doing that only, or it's only reviewing that, then you can still get out of the high risk classification as long as you're not using this for scoring. So this ties up to the first question that you asked me. Is this going to be great for lawyers? Yes, it's very complex, because are you using this for hiring? So it's high risk, but wait. How are you using it? Is it only for a narrow procedural task? Is it only to improve the result of previously completed human activity? Then it might not be high risk. But wait. Are you scoring? Are you doing profiling of natural persons in that regard? Well, then it can become again. Then to your question, do the applicants have a right to an explanation? Well, we have to go to Article 86. Well, Article 86 has all these kinds of requirements. Does it have a high impact on fundamental rights or no? Then everything's up for discussion. In the end, I think the short answer to your question is, if a jury or a hiring panel and so on is using an AI system, that should be disclosed. And they should consult with lawyers specialized in AI, and they should come up with a formula that exempts them from explaining their decisions, much like it happens today. It's like the jury consider all the relevant factors and believes this is the best candidate.
Yeah, exactly.
Yeah.
Okay, thank you. I'm going to go a bit off the script here. I think maybe even off the topic of the panel, but I will apologize later. Better apologize than ask for permission. I think we are in agreement in general that the application of the AI Act and related legislation will not be a trivial thing, right? And it may impose barriers or difficulties on creating new companies or products from big companies and so on. So there is the hope that this will have the Brussels effect, right? That will be the first, and then that other countries, maybe the United States, maybe some states in the United States will follow these ideas of safeguarding individual rights, and in the end we'll have an even playing field. What is your take on that? Will that most likely happen? And if so, I think we'll all be happy because there'll be. And if that does not happen, will this be an obstacle to development of companies in Europe as compared with companies in the US and also in China that, as you know, is different? So my question is, are you hopeful that the Brussels effect will occur in this particular instance? And if it does not occur, can this play against us in what regards competitiveness of our companies? Maybe Mario first.
Well, I have no idea. That's a good. That's not a good question for me. I don't know. I think it's very hard to tell. I think sometimes the fact that you are under constraints actually stimulates your creativity and forces you to look around and to find more efficient or better solutions. It can be a stimulus. So I never forget that before the fall of the Soviet Union, we met scientists from the Soviet Union who didn't have access to Western computers, and they were much better so their software was much more efficient. Right, there was a lot more brain power because they needed to use much weaker hardware, and they were under so much tighter restrictions on what they could do. So it could be a stimulus. So it could actually turn out to be a stimulus. I'm typically optimistic, and I think I agree that Europe should lead from that perspective, as was mentioned in the previous panel.
No. What's your take on that?
My take is.
But I'm no expert.
There's
so my level of
I guess
confidence.
no one is an expert really on this. But
in terms of marketing, I think there's a lot of certified lawyers that can sell you a lot of stuff about this already, even before it is enforced. But in terms of the Brussels effect, I think there's hope, which is standards, which basically, and I think that's the road, which is companies will basically pay a fee. They will do some consultancy work with Deloitte, Capgemini, PwC, any of those companies, or law firms can still enter that market. They get a few stamps, they comply with these few standards, they get a certification, a seal, a CE marking, and they're good to go. If that's not too cumbersome or too expensive, then this becomes just like importing sunglasses into the EU. The other possibility is what is Luciano Floridi has called companies will be VAIing or remain on the safe side of artificial stupidity rather than artificial intelligence, which is we'll be getting worse products in the EU than in the US, for instance, because we have too stringent of a regulation. I don't think that we'll have a Brussels effect in which there will be a strong push to copy legislation that is as complex as this one. It might be that there's an ISO effect if there's a strong standard that is developed to meet the AI Act, and that becomes sort of the rule, much like we've seen in cybersecurity where there are standards that are sort of used everywhere, or much like if you're a EU company and you want to do and sell software in the US, you'll go through a SOC 2 Type 2 or SOC 2 Type 1 and then Type 2 assessment in terms of cybersecurity to be able to sell. So I think that the Brussels effect, if it happens, it's going to be through standards in this regard, not through laws.
Do you know, are there any efforts on that direction of an ISO standard for
Yes.
AI? I never heard about that.
Yeah, there are many. I'll paste that in the chat.
Okay, very interesting. Tobias, what's your take on this?
Yes, I think I would distinguish between the general principles, which I think will be adopted in other places, and maybe this specific type of CE marking approach with the new legislative framework and all the product safety rules, which is the very specific EU type of regulation that was applied here, which makes it very complicated. And so I think for the first one, yes, I would assume that there will be some kind of Brussels effect where the general principles, they are universal. You can also find them in OECD declarations, and probably what is being discussed in Seoul isn't that different. And also, there are also transplants in this field already in many fields. So it may be the case that certain provisions are transplanted. So, for example, the provision that you mentioned a bit earlier today in terms of what are high-impact AI systems with systemic risks, I think that might have been a transplant from the executive order in the United States, which had more prescriptive language on specific details. So these transplants happen, but then one part is taken and then put somewhere else. And so I think what will happen in terms of transplants will be the general principles, many of the obligations under Chapter 3, or the main obligations for AI providers, those will be adopted. But the whole bureaucracy, to call it that, of CE marking and notified bodies and so on, I don't think that is a model that will necessarily make it to other countries, because I haven't seen any similar approaches. But I'm not an expert on that, so maybe there are similar formats to this CE marking and product safety.
Mm-hmm, mm-hmm. Very good. Yeah, no, I was just thinking of a case, as you know, the Australia and Canada imposed a law where the search engines have to pay when they direct searches to news agencies. So we have to pay for each link that they put. And what Facebook decided to do in Canada was stopped using links for news sites. So I mean, these big companies, they have ways to act that circumvent sometimes the letter of the law, and in some cases and the work against the original intent of the law. The original intent of the law was to provide money to the sites that create the news, and it just worked the other way. So do you think that can happen here, in the sense like the artificial stupidity that Nuno was referring to? So I mean, if this application is not doable in Europe, then we'll just do a watered down version and not run into this. So maybe I'll just give the word to the three of you for a final comment and any comments that you want to do. Starting with you, Nuno, now this time.
Well, I think this is fascinating, and I understand that the AI Act is already a hybrid, because it started as a product safety legislation, then the GDPR approach came in, and so in other presentation I said this is like a liger. So you can have a lion with a tiger, a female tiger and the male lion, and you get a liger, but it cannot reproduce. So I think what happens is this hybrid of a legislation is not a species because it cannot reproduce further. And I think having that as a map for worldwide regulation is going to be hard. The market dynamics on this also depend on something that the EU is terrible at, which is marketing.
Which is?
Marketing. So selling this. And actually, it's very hard to sell this where the money and the technology is, which is the United States and to a different extent, China. And some critics have said that from a worldwide perspective, if we have to choose our allies and fight companies out of Europe, then maybe we shouldn't be focusing too much on US companies, because after all, in terms of value alignment, they might not be the worst for our European way of life. At the same time, it shouldn't be seen as the Wild West. And I think actually the end result, so the answers that you end up giving to legal questions under the Act are good. It just takes so long that I'll lose half of my audience meanwhile. So this is so complex that once you see the final result, the answer is actually not that unreasonable. But the problem is there's so many, it's such a long path to get to the reasonable answer that you might lose a lot along the way.
Thank you. Tobias, any?
Yes, I agree that the costs of compliance will be significant, and for companies such as Amazon, that's reasonable, and they will be able to deal with this. But even those companies, we saw that last year, Google waited a little bit with releasing its AI model for the EU because it probably needed to align finish some data protection assessments and so on. So I think we may see delays, but it will be certainly quite challenging for startups globally to market their products in the EU, because the compliance costs are high, the fines are also high, and the level of uncertainty is probably quite significant at this point. So I would expect that certain products are, at least initially, not launched in the EU and first tested somewhere else. And in the long run, this may affect innovation.
It's not that we are extremely well placed in terms of turning innovation into big companies, right? I mean, Mario?
So I probably will finish with a question, which for the people who know about the AI Act. Well, so one common trend, one current trend in developing AI systems is to use a general purpose AI and somehow use them using prompting to address a specific problem, which could be a high risk or an unacceptable risk. So in that case, when you're using general purpose AI to address a specific problem, not just as a ChatGPT, but so there's a core that's a general purpose AI tool which you wrap around some interface to address a specific problem, which could be like applications, grading applications for the university or grading exams or whatever. So where in the law does it fall? In general purpose AI or in the where?
Yeah, before you go, before you go answering that,
so
this is a very important issue, because I mean there are many ways to wrap or to use an LLM as a module of a more complex system. You can use retrieval augmented generation to make it answer questions about, I don't know, taxes or divorces or whatever, things that we are doing now, or you can use careful prompting to make it. And then you take a system that may not by itself be as dangerous, it's quite a reasonable system, but then it can give you wrong answers on important questions, right? How do I file my taxes or so on? So yes, no.
So both. The AI Act has a pretty reasonable answer to that question. So if you go to Recital 97, you'll see that basically the AI Act, and this follows the OECD guidelines, is focused on AI systems. So basically, all of the computer interface, everything you need to solve a problem, to do something, or as an application. But it recognizes that Claude, Gemini, GPT-4, whatever we want, are models. And models are regulated only in as much they are generally applicable. And the biggest concerns around models is about the downstream effects. So basically, if you use the OpenAI API to build an application to grade systems, you're actually the deployer of a high-risk system who's using a general-purpose model. OpenAI, as the providers of the API, will follow under the Chapter 5 and will have a few obligations, namely obligations to provide information to Professor Mari, who's doing the grading AI system. Professor Mari, who's selling and doing that grading AI system, will be the provider of a high-risk AI system. So basically, the generality of those systems is contemplated, and they are not regulated as systems, but rather as models. and then whatever particular user application you build on the basis of those models is dealt with by application as a system.
And this is a very important clarification. Right?
Yes, yes. Tobias?
So just to add something, this is also the key to understand the open source exemption. So basically,
Yes.
the AI Act does not apply to the making available of open source models. However, the fact that your system uses open source is immaterial. Right. So you will fall under the AI Act if you're using a model, if you're using a system, regardless of the code and the data and the weights being open or not. The open source, so Llama, the making available of Llama, not as a system but as a model, is excluded from the AI Act. Once you deploy Llama as part of your application, you're doing an AI system, risk classification, boom, you're in.
Thank you, Tobias.
Yes, so it means in practice that if you're a fast programmer or a fast user of these systems, then you could create such a system within 4 hours, and then you would spend 4 months plus with compliance work. But in some respect, I think that might be reasonable if the system is really about making systems that would be used in practice. But I think it's this creativity and trying out new things which might be at some point a bit hampered. So it might be a fun afternoon project to test the system like that, and I might consider putting it up on the internet, but then I would be the provider of the AI system, and then I would have to deal with all this compliance work, even though it was just a fun afternoon exercise.
Okay. Thank you very much. So I think I messed up a little bit. I should have left more time for questions from the audience. I was just called my attention to that, but we still have time. We have about 5 minutes for that. So if there are any questions from the audience, we can. Maria Manuel.
Catch me, micro.
This way, this way. Ah, there you go. Oh.
Oh, la la. Very original. Only a small comment on what Nuno said at the beginning of its intervention about the complexity of the regulation, the AI Act, of course. It's possible to do better? No, it's not possible to do better, considering the system, how we legislate at European level. First, the proposal of the Commission, and even when the proposal of the Commission is a good one, not always, but sometimes it happens, the Parliament, with these amendments and this procedure of negotiation, probably are going to make it a little bit less better and more complicated. And after the negotiation with the Council and also with Commission present, it's not co-legislator, but in fact, it's co-legislator too, because intervene. Sometimes we need to tell the Commission that they are not co-legislator. They were not co-legislator. We are the legislators during the negotiations. It's very difficult. Even considering our culture, our legal culture, our systematic, the way that is very clear, we organize the laws here in Portugal and even in Germany. It's our common culture, legal common culture. I don't know where this culture comes from, maybe Anglo-Saxon more than Europe continental one, but it's very difficult to make things easier. For me, that I'm a Simplex, I was the owner of Simplex here in Portugal, was a difficult period of my life, looking to this kind of legislation. But when we have this so complex that is artificial intelligence, I think it's almost impossible to do better. It's only to share with you my experience from the Parliament. So it's our task to translate the task of the lawyers, but the task of engineers, and also the task of multidisciplinary teams now to translate it in clear and simpler rules through guidelines and so on. So sorry to tell you that from my experience, even about the common charger and the other very, very simple matters, it was very difficult to legislate in a very clear. So many recitals, so many aspects in a single number of an article.
So it's a complex topic on a complex environment. So
it's very complex environment that make complex every topic.
I think we still have time for one more quick question.
Anyway, it's better to legislate than doing on.
Okay, if there are no more questions, thank you very much for your contributions. I certainly learned a lot about the AI Act. I might even consider reading it in its completely over the summer, the 464 pages of it, right? So thank you very much.
Thank you.
Thanks, everyone.